Now, this issue comes into our office all the time. It's the equivalent of somebody gets charged with a crime and they're saying, well, the victim doesn't want to press charges. Surely the case can be dismissed because the victim doesn't want to press charges. A lot of people think that the victim has to press charges. That's just simply not true. That's not how it works. Here's the truth. The district attorney or the city prosecutor is the person who has control of whether charges are pressed or not the alleged victim in a case. The victim does not decide whether to file charges or drop charges. The victim's wishes may be considered, but they do not control how the case goes. You may notice on every single document you get in a criminal case, it's going to say either the state of Kansas versus you, or whatever city is prosecuting you versus you. It doesn't say the alleged victim versus you, because the parties involved in the case are either the state or the city and you. Now, a lot of people say, well, surely if someone is charged with a crime and the person that they allegedly committed the crime against doesn't want the case to go forward, that the city prosecutor will surely think about that, or the state prosecutor will surely yield to that person's wishes. There are a lot of reasons where the prosecutors may still move forward with prosecution even without the victim's cooperation. You have to think about this practically. If every time someone is charged with a crime, the alleged victim then says, I don't want the case to be prosecuted, it will be the same people in the courtroom over and over again, because the person who allegedly committed the crime is never getting brought into court and having to address the underlying reasons that they're there. Also, you have to remember that in some cases, depending on your admission, the prosecutor may be able to move forward without the witness. They could look at other witnesses. They could have physical evidence, police reports, body cam footage, 911 calls. This happens a lot in domestic violence cases where victims may later want the charges dropped. The state is not in the business of filing charges against somebody and then dismissing them just because the alleged victim changed their mind. Now, there are cases that might ultimately be dismissed if the victim is an integral part of the case and refuses to testify, or there wasn't enough evidence without the victim there testifying. And if the person moved away, left the country, or something like that, then a prosecutor may not be able to meet the prima facie evidence necessary to prosecute the case. You have to remember, it's ultimately the prosecutor's decision, not the alleged victim. Now, why this matters is defendants should never assume charges are going to vanish just because a victim changes their mind. Only the prosecutor or the judge can officially dismiss a case. Remember, victims don't press charges. Prosecutors do. Even if the victim doesn't want the case to go forward, the state may pursue charges if they think they can prove it.